Yes, Madam.
My Lord, I've more or less indicated the three reasons which, according to me, strike a note of caution in relation to answering this reference. And, my Lord, it was suggested, just by way of an aside, that one problem with the judgment in Bangalore Water Supply was that the Justice Beg was due to retire. But it will be my submission that amongst the separate judgments that are rendered, the most precise and concise articulation of the definition of industry is in Justice Beg's judgment, and I will be taking you to that judgment. My Lord.
In any case, these issues are inconsequential now.
My Lord, yes, but when learned seniors get up and start attacking judges, I don't know what to do.
You can ignore it from our side. We can start.
Very well. Very well, Lord. But I just wanted to point it out that I will be drawing your attention to Justice. My Lord, on the merits of the case.
Yes, why not?
I will put it all in writing and I'll give it to you. This is only to indicate to you how my argument is going to flow. Well, on the merits of the case, it is going to be my submission that Bangalore Water Supply has been decided according to classical principles of interpretation of statutes. Now, what are these classical principles, my Lord? There are classical principles for interpreting what are known as beneficial statutes. And the Industrial Disputes Act has been characterized by several judgments of this court as a beneficial statute. Now, my Lord, the classical principles are, look at the provisions of Part 4 of the Constitution, read the plain meaning of the section, look at the object of the Act, read the preamble, see how the Act achieves that object, and interpret the words according to those principles. Maxwell, Hayden, take it from anywhere you want to take it. These are classical principles, my Lord. And my submission is these classical principles have been used in Bangalore Water Supply to come to the conclusion they have come to. Therefore, my Lord, no case is made out for
Revisiting.
differing with the judge. That's the first point. Second thing is, when I say it's a beneficial statute, what do I mean by that? My interpretation of that. Well, Lord, remember, the Industrial Disputes Act of 1947 is actually a pre-Constitution Act. That's the first point. The second point is, my Lord Justice Dipankar Datta hinted at that, but I will give you a judgment to support that proposition. It gave to the workmen security of tenure, which an ordinary civil court cannot give. My Lord, an ordinary civil court is bound by the law of master and servant classically under common law and has no jurisdiction to grant reinstatement. At best, they can give you damages.
Yes.
Now, this lacuna is cleared by the Industrial Disputes Act of 1947. Because under the Industrial Disputes Act of 1947, the relief of reinstatement can be granted. Now, my Lord, why? And especially when Section 11A was introduced into the Act in the year 1971. Now, my Lord, Justice Datta hinted at that what exactly is the jurisdiction of a labor court? How does it differ from the jurisdiction of a civil court? So, my Lord, there this court has held that a labor court can de novo exercise its jurisdiction to decide whether the dismissal is unfair, justified, and whether the punishment is proportionate or not proportionate, which is something no civil court can do. So when we want protection under the Industrial Disputes Act, we are asking for protection for security of tenure.
Yeah.
It departs from the rule of hire and fire, which is the classical rule under common law. So, my Lord, this is not a futile fight. This is not a fight for gratuity. Labor law has two components to it. One is security of employment, which is most critical. And the second is welfare benefits, such as gratuity, such as hours of work, such as maternity leave, such as provident fund, such as employment ESI. These are the welfare benefits. that different statutes give us. But the primary security of employment comes from departing from the rule of hire and fire, and that is what this fight is all about. Now, that being said, my lord, the next question posed is, there are certain rules and regulations and constitutional provisions which govern a whole lot of employees. There are, my lord, one of the most fundamental articles in the Constitution of India is Article 311 of the Constitution of India. My lord, if we are covered by 311, we are not asking for coverage under the Industrial Disputes Act. We are here talking about those who are not covered by 311 and 309. This is the reply, my lord, to Mr. Nafde's argument that no, departments of the government should not be covered. Then he must answer the question, are they covered by 311? Are they covered by 310? If they are, we have no problem. This court has upheld the constitutional validity of the Administrative Tribunals Act. Every state has an administrative tribunal of its own, where we can go for relief from unfair dismissal. And the protection of 311 goes beyond the protection of the Industrial Disputes Act. So we are not stupid people that if we are covered by 311, we will clamor for coverage under Industrial Disputes Act. So my submission is this, that every democratic society is duty-bound to give access to justice in a judicial forum. And all that the Industrial Disputes Act of 1947 does is give me that access. It doesn't create any major substantive rights. It gives me access to justice in relation to unfair dismissals, in relation to victimization, in relation to malafide dismissals. This is what this court has said. And I will place that judgment before you, how the law comes to be changed when Section 11A is introduced in the Industrial Disputes Act. Lord, straight away I will tell you, is the decision of this court in Workman of Firestone versus Management, reported in 1973, 1 SCC, page 813. There was, my lord, a tangential challenge to the introduction of Section 11A into the Industrial Disputes Act, which granted the relief of reinstatement. And this court then explains the difference between the jurisdiction of a labor court and the jurisdiction of a civil court, and says 11A gives security of employment. That I understood to be because they can record evidence de novo. They can depart from punishment imposed by the employer. And my lord, the doctrine of proportionality comes to be introduced.
Proportionality. That is the most important component, proportionality.
Yes, my lord, proportionality.
Even for the tribunal can, punishment of dismissal removal can be reduced to a smaller, minor punishment.
Yes. You might put the guillotine on a worker
Normally,
for a minor misconduct.
it's a power normally not given even to High Court under 226.
Yes, my lord. Yes, my lord. And under 311, my lord, we know the law. Under 311, my lord, the law goes much further, where who can dismiss you, an appointing authority has to be senior to you, charge sheets have to be given, rules of natural justice have to be complied with. None of this was possible under common law. And we were all governed by the rule of hire and fire. This is the significance of the case before you, my lord. If we get thrown out of the coverage of the Industrial Disputes Act, we go nowhere. I concede, my lord, if I'm covered by another statute which gives me access to justice, I have no complaints. Here the question is of throwing us out of all possible. Now, you have to look at the triple test from these points of view. My lord, the triple test is normative in nature. It lays down norms as to, first of all, my lord, my submission is going to be, there is actually no ambiguity in the definition of industry in the Act. But assuming there is an ambiguity, nobody bothered to clarify what is this ambiguity until Justice Datta pointed out that the definition is in two parts. There are two different parts to the definition. Now, where is the ambiguity between employer and employer, between workman and workman, between workman and employer, which is what I'm concerned with. And, my lord, there are industrial disputes to which I have myself been a party. My lord, Justice Sri Krishna traditionally represented the Textile Association of Manufacturers in the Industrial Court in Bombay, where, my lord, very often we had occasion to appear against each other. But disputes between employers and employees are not unknown. And disputes between employees and employees are not unknown. Classically, they arise when which union is to be recognized. Whether a person, a union which has 50% membership should be recognized or 25% membership has to be recognized. There are endless disputes between workers. They all get resolved in an industrial court. Now, if you look at the triple test from this point of view, you will find that a norm has been laid down to decide what to include in industry and what not to include. Now, my lord, much has been said about charity. Just pause here and see who are the petitioners before you. My lord, I'm rather surprised. I was expecting, traditionally, my lord, over the years, we have faced private employers in a court of law. Firestone, 1971 judgment is a private employer. Today, who's come before you? All the states. Does it not surprise you? Where are the private employers? They're not here. Is this a surrogate fight for them? And, my lord, regardless of who's in power in a state, all the states are arguing. They want this thing, the judgment overruled. Whether it's Punjab or Karnataka, makes no difference. They're all arguing the same thing. They have a common interest to protect. Lord, I don't understand. If that is the case, why did the 2020 code lift the definition of industry from Bangalore Water Supply and codify it? And somewhere, my lord, in his judgment, Justice Krishna says that a definition is the distillation of jurisprudence of law. A careful definition has been put there. Our problem, as I told you, is when you come to the exclusions. And even here in this reference, what is the main argument over here? If only if it is a profit motive, then you call it an industry. That is the argument of all the people, shorn of all other verbiage. This is the one single thing that they are arguing before you. Only if there's a commercial, some dressed it up in semantics. Some said there must be a commercial motive. What is that? Some said distinguish between profit and surplus. What is the distinction? Surplus comes from profit. So therefore, my lord, this is the single attack on this judgment, that charity should be excluded from the purview of this act. Now, my lord, to that the answer is very simple. The answer is charity begins at home. Justice Krishna says, yes, by all means, you do charity to everybody you want to do, but have you done it to your workers? How is your worker concerned if your worker comes to you and says, give me a fair wage? What will you tell him? That I'm a charitable institution, I'm doing charity to the world, but I will not give you a fair wage. This is the issue, my lord, the demand for fair wages. And my lord, temples are before you. They're the richest entity in this country. Temples. Your ladyship referred to the prasad. Yes, there is prasad. Justice Krishna deals with that. He says the spiritual aspect may not concern us, but the person who's making a laddu in the department, what about his wages? So, my lord, the doctrine of severability comes in over there. Yeah. Justice Chandrachud points out that you talk of sovereign functions, but a mint, a worker working in a mint, producing a coin, production of coins is a sovereign function. But what about the worker producing a coin in a mint? He is covered by the industry. That's Chandrachud's judgment. Why be Chandrachud's judgment in the separate judgment? So, my lord, one has to have clarity in one's mind as to what is the purpose of this whole exercise. The purpose of this exercise is access to justice. There is no other purpose behind this exercise, my lord. That is how I would like you to appreciate the judgment of the Supreme Court in Bangalore water supply, my lord. Now, my lord, that being said, as I said, I have filed my written submissions. First of all, my lord, Bangalore water supply, Firestone, I don't think was on the record of the case. If you allow me, I'll just hand over the copies. Give me my copy. I will read only the passage relating to jurisdiction of the court.
There are
Those-
written synopsis. You want to give a written synopsis?
No, my lord, just take a look at Firestone for one moment. I've handed over a hard copy. I will not trouble you with the whole judgment.
Because there is one is already there with soft copy, but we can.
It's on the screen.
Oh, on the screen. Very well, my lord. I'll point you to the relevant passage. If you look at 13, para 13.
So the Firestone.
Yes, my lord. My lord, I must tell you, as a tiny little aside, probably this judgment was delivered before many of us were born. But as a small aside and a minor achievement of mine, I must tell you that I was one of the people who argued this case. I don't like to say it, but I'm saying it. And I'm saying it, my lord, because I was opposed by Mr. M.C. Settlebar and by Mr. Damania, who is the senior of the amicus that you have appointed in this case, Mr. J.P. Kama. These are only small little trivia, but they may help us to appreciate the judgment better. Now, para 13. The above proposition has completely changed by section 11A, which is now obligatory on an employer to hold a proper domestic inquiry in which all material evidence will have to be adduced. When a dispute is referred for adjudication and it is found that the domestic inquiry conducted by the management is defective, or if it is found that no domestic inquiry at all had been held. My lord has got that yeah, been held. Conducted. The order of discharge and termination passed by the employer becomes without anything more unjustified. Now, my lord, please note the use of the word unjustified. It goes beyond a formal appreciation of the dismissal. And the labor tribunal has no option but to direct the reinstatement of the workman concerned as his discharge or dismissal is illegal. Even the case where a domestic inquiry has been held and finding of misconduct recorded, the labor tribunal has now full power and jurisdiction to reappreciate the evidence and to satisfy themselves whether the evidence justifies the finding of misconduct, even if the inquiry proceedings are held to be proper and the finding of misconduct is to be accepted. The tribunal now has the power to consider whether the punishment of dismissal or discharge was necessary for the type of misconduct of which the workman is found guilty. In such circumstances, the tribunal can also give any other relief to the workman, including imposing lesser punishment. In case where no inquiry has been conducted, any inquiry where the inquiry conducted by him is held to be defective, the employer will not be given an opportunity to adduce evidence before the tribunal for justifying the action. Various decisions of court have been emphasized, etc. Lord, this is the passage which tells you what the Industrial Disputes Act really does for workmen. What is its beneficial content? Because we are not just saying that there is a beneficial content, we are pointing out to you what is this beneficial content. And my lord, ultimately at page para 35, they say that various arguments have been advanced, but they uphold that interpretation in which I've read out in para 11. Your lordship need not read any more. And just see para 50. Again, the same considerations. The legislature in section 11A has made a departure in certain respects in the law as laid down by this court. Now, my lord, the law as laid down by this court went on classical principles of hire and fire. For the first time, power has been given to a tribunal to satisfy itself whether misconduct is proved. This is particularly so, as already pointed out by us, regarding even findings arrived at by the employer in an inquiry properly held. The tribunal has also been given power, also for the first time, to interfere with the punishment imposed by the employer. When such wide powers have now been conferred on tribunals, the legislature obviously felt that some restrictions have to be imposed regarding what matters may be taken into account. That's, my lord, on the criteria for deciding the principle of proportionality. So, my lord, I place reliance on this judgment for supporting the proposition that this is the beneficial statute. That is
That's-
the main issue. If this is the beneficial statute, my lord, it follows that its interpretation must be done in the light of directive principles of state policy. And that is what this court has held in Bangalore Water Supply. Now, my lord, because fun was made of the fact, and Mr. Nafde used the word, we need to now be objective about it. What is the meaning of the word objective about it? Either it is a beneficial statute or it is not. One of the two. Where is the objectivity there? It's a pure statement of fact. You agree or you disagree? It's a beneficial statute. If it is, then a certain interpretation follows, because directive principles of state policy are also binding on this court in the interpretation of statutes. It has been so held by this honorable court. Now, my lord, this being said, I will take you, my lord, to the written submissions, except that there are two sets. One was formulated after listening to the arguments of my worthy opponents, and the other before listening to them. So, my lord, if your lordship can take the second set first, and then I'll bring you to the first, and I'll conclude with my arguments. The second written submission I've filed.
Official legislation is taken note.
It is. I'm not going to trouble you, except I will read passages from Bangalore Water Supply itself. I'm not going to take you to texts and volumes and this and that. No. Because I'm urging that for acceptance by the court. My lord, if your lordship takes the second set of written submissions.
It's the wrong place. It's for the workman.
Yes. It's foundation is from now.
The solution section of replica. It was written.
My lord, I won't take up too much of your time. I'll run you through this quickly, because by now we are probably suffering from fatigue also. So it's true, my lord, even I am suffering from fatigue. What do I do? Yes, my lord, my learned companion senior tells me it's called combat fatigue. Combat fatigue, yes. My lord, if I may quickly run you through this. My lord, the first point I've said is the reference should not be heard, but kindly don't get alarmed, because I've made my submissions in the alternative. I'm assuming that the reference is not going to be discharged. I've made submissions on both sides. So, my lord, the first point, and I will be addressing you a little bit on sovereign functions, because sovereign functions is also one of the issues which bothered the court at the time of at least the three judges who made the reference to the Chief Justice. They talk only of sovereign functions. They don't talk about anything else. I'll point that out. Therefore, it's necessary to address the issue of sovereign functions also, because three judges were alarmed by sovereign functions. Now, my lord, I'm saying that the reference has been on erroneous. So the first is, my lord, the President, along with the other connected cases, has been listed before the Constitutional Bench of 5 judges on a reference bench of 3 judges of this court, finding an apparent conflict between the decision of the 2 judges of the court in chief conservator and Parmar. On the question whether social forestry department of the state, which is a welfare scheme undertaken by improvements of the environment, would be covered the definition of industry under section 2J of the Industrial Disputes Act, the aforesaid benches of this court called out differently the ratio of the 7-judge bench decision of the court in the case of Bangalore Water Supply, hereinafter referred to as Bangalore. The bench of 3 judges in the case of Chief Conservator of Forest, based on the decision in Bangalore Water Supply, concluded that the social forestry department is covered by the definition of industry, whereas the 2-judge bench decision of the state and Parmar took a different. Well, this is incorrect. I'll point out from the judgments it's incorrect. What Parmar, first of all, conservator is a decision of 3 judges. Parmar is a decision of 2 judges. If there was any difference of opinion, my lord, the reference could have been made at that stage. No such reference was made. Why? Because the court in Parmar differed on facts. They said that the employee has not submitted that he is working in an industry. And therefore, the High Court has gone wrong in deciding that it is an industry because no such issue was raised. So there's a conflict of opinion. They don't overrule or nor do they seek to differ from conservator. I will read conservator. Conservator basically talks about why social forestry is not a sovereign function. That takes you into the arena of social welfare. What is welfare? My lord, we don't have a definition. I'll take you to that. So when I say it is respectfully submitted that the error seems to have arisen in the order of the bench of 3 judges. And I'm quoting that order. One of the contentions which arises for consideration is whether the social forestry department is a scheme of the government, is an industry or not. Our attention has been drawn to the 2 decisions of the court in Conservator and in Parmar. And finally, they have taken a different view and sought to distinguish the earlier decision of Conservator. It is submitted that the 2-judge bench in state of Gujarat did not take a different view from the Chief Conservator on the question whether Forest Department is an industry, but held that the workman in question had not asserted that it was an industry and that therefore the High Court erred in holding that it was an industry. Finding turned on the question of fact, not of law. It is thus clear that there was no quote-unquote cleavage of opinion, as noted in para 3 of the reference order, since the decision in Parmar did not take a different view that the Forest Department is not an industry. Next, my lord. Hence, no cause arose for the 3-judge bench to lay the papers before the Chief Justice. Next, my lord. The further reason for discharging the referent without any opinion is contained in para 24 of the reference order. In any case, no such provision limits the power of the bench of 5 judges, which has been constituted on a reference made due to apparent conflict between judgments of the 2 benches of this court. As has been stated by us above, the decision in Bangalore Water Supply is not a unanimous decision. On the 5 judges who to the majority, they have given a common opinion, but 2 others have given separate opinions, project partially different from the views expressed in the opinion of the other 3 judges. Justice Bate, Chief Justice, having retired, had no opportunity to see the opinion. This is in the reference order I'm reading. Had no opportunity to see the opinion delivered by the other judges subsequent to his retirement. Krishna Iyer and the 2 judges who spoke through him did not have the benefit of the dissenting opinion of the other 2 judges and the separate, partly dissenting opinion of Justice Chandrachud, as those opinions were prepared in. Now, what is a sequitur? That is not mentioned. Does it follow that Bangalore Water Supply is not a judgment in the eye of law? That is the question you have to answer. It remains a judgment in the eye of law. Notwithstanding anything, but not judgment is defined in the procedure code. Go read that definition. It is a judgment. And not only is it a judgment, it's a judgment of 7 judges. Now, my lord, have made that clear also. Bangalore Water Supply was a decision of 7-judge bench, regardless of the fact that 5-judge majority was formed with 2 dissenting opinions by 2 judges. The judgment remains a judgment of 7. I've given you the citation. I will not bother with the citation because it's a well-known proposition of law. But the citation has been given. In para 19 of the citation, it is made clear that regardless of dissent, because of Article 145 of the Constitution of India, it remains a judgment of 7 judges. It may be noted that the decision in Safdarjung is oddly a decision of 6 judges where there could have been a split, whereas the decision in Bangalore Water Supply is one of 7. Now, my lord, that completes that. I will not trouble you anymore with that. Let me now go to another issue. My lord, what I'm arguing is that there is not enough data before this reference to answer this question. And I'm recommending that your lordship calls for that data. Now, what is the data? As has been conceded by the learned Attorney General of India, any outcome in the present reference would be applicable only to pipeline cases. That is, those pending for decision before the repeal of the Industrial Disputes Act by notification date is so and so. It is thus suggested that before any judgment is delivered in the present matter, this Honorable Court may be pleased to direct the states, because they are the main litigants before you, to submit data of cases pending under the ID Act, indicating the organizations which they cover, whether university, club, hospital, whether for profit or not, social welfare activities, municipalities, local bodies, and the state. The data will give us a picture of the nature and extent of the issues for determination before this Honorable Court. It will also ensure that the court is not deciding academic issues. Now, my lord, the note of caution I've already rendered. I'm only pointing out that without doubt, the code of 2020 is going to be challenged to the extent that it excludes charities and fails to define what is a sovereign function. It fails to tell us the meaning of social. It fails to tell us the meaning of philanthropic. We have to struggle here and there to find what is the meaning of these things.
What data is important?
Now, my lord, I'm moving on to the merits of the issue. Now, my lord, I'm done with the reference order. Let me move on to the merits of the case.
It's always following PWS.
Principles of interpretation, this is what I said are the classical principles, my lord. I'll just read it out. Culled out from the judgment itself. At the outset, it is stated that the submissions herein below are without prejudice to the above submissions. The most concise statement, articulation of the interpretation of statutes in Bangalore Water Supply is found in the judgment of Justice Baig, and I've reproduced it, my lord. The method which has been followed, whether it is called interpretation or construction of a part of an organic whole, pause here for a moment, my lord. We are only urging before you to read the statute as an organic whole, which is what Justice Krishna did, in which the statute, its objectives, its past, and its direction for the future, its constitutional setting are all parts of this whole, which this, with their correlated functions. Perhaps it is impossible in adopting such a method of interpretation, which some may still consider unorthodox, a certain degree of subjectivity. But our attempt should be not to break the well-established principles of interpretation. In doing so, progressive, rational, and beneficial modes of interpretation import and fit into the body of the old what may be new. It is a process of adaptation for giving new vitality in keeping with the progress of thought in our times. All this, however, is not really novel, although we may try to say it in a new way. If one keeps in mind what has been laid down in the Haydn's case, referred to by my learned brother Justice Krishnaiyer, the well-known principle that a statute must be interpreted as a whole in the context of all the provisions of the statute, the object, the preamble, and the function of various provisions, the true meaning may emerge. It may not be strictly a dictionary meaning in such cases. Indeed, even in the modern statute, and the meaning of a term such as industry may change with a rapidly changed social and economic structure. For this proposition, I can do no better than to quote Justice Subbarao, speaking for the court in so-and-so court. The legal position may be summarized thus. The maxim contemporario expositio, as laid down by Cook, was applied to construing ancient statutes, but not to interpreting acts which are comparatively modern. There is a good reason for this change in the mode of interpretation. The fundamental rule of construction is the same, whether the court is asked to construe a provision or an ancient statute or a modern one, namely, where it is expressed intention of the legislature, it is perhaps difficult to attribute to the legislative body functioning in a static society that its intention was couched in terms of considerable breadth as to take within its sweep the future developments comprehended by the phraseology used. It is more reasonable to confine its intention only to the circumstances obtaining at the time of the law was made. But in a modern progressive society, it would be unreasonable to confine the intention of a legislature to the meaning attributed to the words used at the time the law was made. For a modern legislature making laws to govern a society which is fast moving must be presumed to be aware of an enlarged meaning. The same concept might attract with the march of time and with the revolutionary changes brought about by social, economic, and political and scientific and other fields of human endeavor, activity. Indeed, unless a contrary intention appears, an interpretation should be given to the words used to make the new fact situation in the words are capable of comprehending them. Now, this is this interpretation of statute which has been used by the three judges, by Justice Baig separately, and my lord, also by Justice Chandrachud separately. They're using the same principles, my lord. I therefore submit, my lord, no case is made out for reconsidering the decision unless you come to the conclusion that they have not used these principles.
Yeah.
No. There's no point in saying I take one view, you take one view. The stare decisis it has held the field for 50 years. Close to 47. I was making the calculation. Then, my lord, I come to the object.
48.
48.
February.
My lord,
We are now in March.
pardon me, my lord, if I'm vague with my dates. I'm a dinosaur in this courtroom. I just told you that I appeared in a 1971 judgment of this court, so I tend to forget years. Next, my lord, the object of the Industrial Dispute Act 1947 is to provide a judicial forum. I've said this, is to provide a judicial forum in which disputes arising between employers and workmen can be resolved towards the achievement of industrial peace. How can we forget it? That the purpose of the act is to achieve industrial peace. My lord, it lays roadblocks and barriers and draws red lines on the right to strike. If it was not for the Industrial Disputes Act, Lord, you would see wildcat strikes all over the country. The minute a dispute is admitted in conciliation, strikes become illegal. The famous Gujarat Steel case of this court, Lord, again decided by Justice Krishna Iyer, whether 300 people were dismissed from going on an illegal strike. Why? Because conciliation proceedings were pending. So the whole object of this act is to prevent that kind of illegal strike. And to make conciliation possible, and my lord, to divert disputes from the street to the courts. So it is in the interest of employers and employees to have the Industrial Disputes Act in place towards the achievement of industrial peace and the avoidance of conflict in the form of strikes and lockouts. Although the right to strike forms part of the right to collective bargaining, the Act seeks to regulate that right, essentially when it comes to, now, my lord, this is the real giveaway, especially when it comes to public utility. Now, my lord, the argument that this Act cannot apply to governments is given away the minute you read the definition of public utility in the Act. It squarely covers governments. Give me the Act, please. Let's pause and read the definition of public utility. In public utilities, my lord, strikes are actually prohibited. Why? Because it is in public interest that essential services are not disrupted, my lord. Say fire services, say hospitals. My lord, 2N. 2N. And this is what Justice Krishna Iyer uses. 2N, public utility service means railway service. Who runs railways in this country? Any service in or in connection with the working of a major port, dock, industrial establishment or unit engage in essential defense services, any section of an industrial establishment on the working of which the safety of the establishment and the workman employed therein depends, postal, telegraph, telephone, any industry which supplies power, light, water, public system of public conservancy and sanitation, any industry specified in the first schedule. Now go to the first schedule, my lord. All these are public services, public utilities, where strikes can be completely banned in public interest. Now let us look at the list of services. In the teeth of this, my lord, how can it be argued that enterprises run by the government cannot be covered by this act? Which was the argument made before you by Mr. Justice by Mr. Nafte. Please see at page schedule 1 to the act. Transport, other than railways, for the carriage of passengers or goods by land or water, banking, cement, coal, cotton textiles, foodstuffs, iron and steel, defense establishments, services in hospitals and in dispensaries, fire brigade services, Indian government mints, obviously all covered by the act, therefore excluded. Indian security press, copper mining,
Surveys,
lead mining, zinc mining, I know.
sir. Then there is doctrine of severability.
Not such a given one interpretation according to direct influence. That is totally.
These are the hospitals that came before this court. Safdarjung Hospital came before this court. How does it lie in their mouth to say that we are not an industry? Well, look, that is as far as interpretation is concerned. I come back to my written document.
Commission that this is a welfare legislation. If two constructions are possible on a reading of the legislation, you find out what is the object of the act and thereafter read it in a manner so that it furthers the welfare of the class of people for whom the legislation has been brought.
Lord, with respect, yes, my lord. Except that I've explained what I mean by betterment of by beneficial to the people. By that I mean access to justice. That's all we're asking for. We're not asking you reinstate me now. We are just saying give me an opportunity to go to a competent court of law and ask for myself to be reinstated when I'm fired from my job. That is the purpose of this legislation. Yes, my lord, your lordship.
I think broadly there is no dispute about it. That it's a beneficial legislation as rightly argued. You are also rightly saying that the workman who will be covered under within the ambit under this act is entitled to certain statutory protections. Like you were referring to wages. Wages are not covered under this act, but there is a payment of wages act, minimum wages act are there. Those statutes are there.
Yes, my lord.
Factories act, there are certain.
Yes, my lord. Yes, my lord, the argument.
But retrenchment part is taken care of.
Yes, a reinstatement. Reinstatement is taken care of.
Disciplinary action is taken care of.
Yes, it is.
Quantum of punishment is taken here. So you have in 11A mini 142.
Yes, my lord.
In order to do complete justice,
Yes.
11A gives kind of that power which normally.
Your lordship said it, hit the nail on the head. I didn't want to use 142 because we have a lot of complaints about
No,
142.
we are
Leave
saying
that
only
aside.
meaning that when you want to use, you use 142. When you want to criticize, you criticize 142. That we understand. That's the prerogative on this side.
But I'm not opening my mouth on 142.
No, no.
142 was used in the Union Carbide case.
Anyway, it
I
has
rest
been,
my case.
it
I
has-
don't want to
it
say.
must have been used 100 times in your favor also, that we are not on that issue. Because that is the privilege on this side. You can argue.
My lord, yes, my lord, but there are powers akin to 142 to
Yeah.
do complete justice. I agree.
Complete justice, where, because 11A is an instrument given
Yes.
to the tribunal or the court,
Yes, Lord.
industrial court, to do that when you find that offense is, say, the misconduct is very small, the punishment is coming like a hammer, why it should be dismissed? Why not a warning, censure, stoppage of one increment, a small increment, which save the employment, which family is saved. So all these powers are definitely there. Ultimate issue probably both sides is that who are those workmen? It's a question of identifying
Yes.
who are those industry,
Yes.
whose workmen,
And who are those workers?
whose workmen are
Yes.
entitled to
Yes,
protection.
because those who are covered by other better legislation, we are not asking to bring them over here.
But there your argument is that this being a beneficial legislation, one, it should be a very liberal interpretation. And liberal interpretation, the endeavor should be to include as much establishments as it can be, unless there is an express or implied bar which will really prohibit to declare someone as industry. Probably that is the
Yes, my lord. Now that
broad
question,
framework of the argument.
my lord, the question of express exclusion will arise in the 20 code. There is an express exclusion over there. So that is a battle for another day. Don't worry, my lord, we'll be here back before you.
The charging provision, so to say, in the sense what triggers the act is actually not the workers. We are putting this question to you because I'm looking for an answer. It doesn't go by the workmen. It goes by the definition of an industry. So therefore, through the window of the industry, that the act which stitches large number of remedies, also provisions a number of protections. But for accessing all of them, the window is through the definition of industry. But your emphasis that it is worker based and protection of the worker is slightly different, despite the fact a group of workers in a particular organization might definitely need that kind of a protection. But if it so happens that the industry doesn't come within the ambit or the net of the act, then that's not accessible. Just explain that, please.
That, my lord, Justice Krishna takes care of that while dealing with charity and classifying it into 3 different categories. The third one, he says, is purely spiritual. And he also points out that there are organizations where there is self-service, like in an ashram. The activity may be organized. It will fulfill the first 2 requirements, or it might fulfill all the requirements, the triple test. But however, the labor may be voluntary. Well, there are many organizations in which I wash my own dishes. I self-serve my food. I wash my own dishes. It's a form of seva. So perhaps that is the window of organizations which will not be covered. Well, yes, there's so much confusion in decisions of this court. I don't know where to begin and where to end. You just take the question of inalienable sovereign functions. What has been said by this court? Legislature.
It's not the statute. Sovereign was not part of the statute.
I beg my lord's pardon.
That requirement of excluding sovereign
Yes.
functions was not part of the original definition. It came by way of a explanation to the definition.
Yes, my lord. It came on a question what to exclude. It came on that question what to exclude.
Has come from the tort liability issue. Vidyavati
Yes.
case, state of Rajasthan,
Rajasthan versus Vidyarthi, or Vidyarthi
That's
versus
called-
Rajasthan.
tortious liability.
It started with tortious liability, where this court said a truck driver who's hit by a truck, a person hit by a truck owned by the state, whether he's immune from liability or not. The argument was it's a sovereign function. So this is where the line of cases begin. But my lord, it actually begins much earlier. There is a case decided in the pre-independence period whether the East India Company was liable. Because the East India Company had a dual function. It was sovereign function as well as it was a trading company. So there the court says, no, this is not a sovereign function. That gets continued in Vidyarthi. And ultimately, my lord, the whole concept of sovereign function gets abandoned, except inalienable, which is what? Which is legislation, which is justice. Now, my lord, we are told that dispensing justice is a divine function. Yes, my lord, it is a divine function. So maybe it will not be covered by the definition of industry. But I ask you a question. What about a sweeper working in your courtroom? All right, all these staff working here are protected by 311. But there are people inside this courtroom who are not protected by 311. All your canteen contract workers. So many, Milan, the situations can be innumerable. Therefore, the test is, first of all, you have to understand the meaning of sovereign functions. And ultimately, the question raised by my lady, what about LPG? I will answer that question also, my lord. Because at one point it was said that that which cannot be done by a private party is a sovereign function. Now you're allowing your nuclear energy plants to be manufactured by private parties.
So it doesn't depend on who is doing that activity. It is
that
what
is-
is that, whether it is the state, government or private. Because earlier it was all by the government. Now it is all privatization. It is not who is doing that activity. What is that activity is more important, nature of it.
Therefore, it was-
My lady, this is what Justice Krishna Iyer said. It is not the motive, it is the way it's organized. How is your activity? It's a functional definition. How is it organized? Is it systematic? If it's casual, it's not an industry. Is there cooperation of the workers? Yes, it's an industry. So that is why I said the triple test is a normative test. It gives you the norm by virtue of which you're going to take your decisions in times to come. And that is why, all right, my lord, let me deal straight away with the question of charities. Tell me, where will you find a different definition of charity? You will find it only in the Income Tax Act of 1961, section 16. Now you go there and see what is excluded under charity. Every single hospital, every university is a charity. What will you do? They all have exemption under the section 15 of the Income Tax Act. Every one of them. You have the concept of deemed universities now. The private universities are universities. What are they doing? Are they performing a charitable purpose? They are charging those high fees which generate those profits. And what Justice Krishna is saying is, it doesn't matter to the workers whether you put that surplus back into the organization. I'm concerned with the labor I'm putting in it.
Yes.
You are putting surplus, I'm putting labor. Therefore, the triple test. If that triple test is satisfied, how can you exclude charities? You can do as much charity as you want. We are not stopping you, my lord. I have made a note of it. My lord, Tata Sons is covered by a charity. Tata Memorial, Tata Trust, Tata Memorial Hospital is covered by charity.
For the purpose of Income Tax Act.
Yes, yes. Why am I talking about it? Because this act doesn't give you a definition of charity. Where will you look for a definition of charity? You will go to cognate legislation. You will go to other laws which can give you some guidance on what is a charity. Or you might use a layman's understanding that I will give you free food. That is my charity. We all, my lord, all of us at the bar, and my lord, what to talk of professions. Please read the paragraphs in the Bangalore Water Supply about the legal profession. It will be an eye-opener for you. I'm not going to lead. He quotes Shaw, who says all professions are a conspiracy against the laity. What can I tell you about my profession that you don't know already? That we are declaring an income of 3 crores a year. We meaning some.
Is the lawyer's profession was mostly individual based in
We
1970s.
meaning some, you know, I don't declare. an
In
income.
1970s. One of the reasons for exclusion, one of the reasons of exclusion of the profession of, in 70s, it was based, small law firms or individual.
Yes.
Today you have huge law firms.
My lord, I can.
See the kind of contribution made by non-lawyers in a law firm is very proportionately high nowadays than what it was in the 70s. That is what
At this point,
Justice Singh has said.
I want to,
It's a
my lord,
very
at this
useful
point,
contribution.
my lord, I would wish to acknowledge, in drafting my submissions, I would wish to acknowledge my debt of gratitude to two interns of mine who are law students, who have helped me to prepare. This is the contribution made by law students to these written submissions, my lord.
No, the other clerks and other,
Yeah,
those who work on the
yes.
computer, those who take out thousands of pages of photocopies, stenographers. So many non-lawyers are now employed in huge law firms. Now, whether they should be out,
They should not be out, my lord. They cannot be out if you use the triple test. And they can't argue their charities, can they? Well, I will name the firms because they're all my personal friends. I have worked with all of them. I've worked with Cyril Shroff. I've worked with Shardul Shroff. I've worked with Zia Modi. Each one of these was my contemporary, my junior. I know the firms they run. We all know it. So again, my lord, that is for another day. Today, my task is to convince you what is the logic for have been included. Hospitals have been included. The universities, education is included. Well, not in the TMA Pi case in this court, universities, TMA Pi College claimed the protection of Article 19(1)(g). We are an occupation, we are a calling. But are they making money? Yes. Are they a charity? Yes. Well, I went and looked up which of the organizations registered under the Income Tax Act as charity. Half your law colleges are all registered over there. And hospitals.
Yeah.
So, my lord, to exclude them, that is the logic why Justice Krishnaiyer included them. That is my limited submission before you. That please don't interfere with that exclusion at the behest of whom? And on whose behest are we doing this, my lord? And as I said, the curious part, your lordship must investigate. Why only the states here before you? All states. What do they want excluded? They want excluded social welfare. And my lord, a submission was made over here that because of Part 4, they all become sovereign functions. I'm saying you're putting the constitution on its head. Because of Part 4, they all come in. Because of Part 4, they can all be done by the private sector. Because of your LPG policy, they are being done by the private sector. How can you use that as an argument to say exclude social forestry? Even Mr. Nafte was representing forest. I don't know what it is that's about the forest department that makes them so panicky and anxious about the fact that their workers are going under industrial courts. It defies my imagination. I don't know why all cases which come to the court are forest department. And except that I also had the good luck to argue the conservator of forest case, which is the classic locus classicus on the question of sovereign functions, where the court says inalienable. What is inalienable? Your lordship can't alienate the function of justice to anybody. The legislature can't alienate the function of making laws to anybody. These are the classical, and that too, my lord, I've put it in my document, but I want to explain this point. What is it about sovereign functions that makes it excluded? I'll tell you what it is. And it is there in one of the judgments. It is the fact that some of these questions are political questions, classically defined by courts, that political questions not subject to judicial review. Lord, if I were to file a petition before you saying that Operation Sindoor should not have happened, will you entertain the petition? No, because it is because it is a political question, which the court, where there is no judicial review. That is the meaning of sovereign functions, my lord, where the question is a political one. And therefore, no court of law can question it.
Yes, we got it.
So therefore, my lord, let us be very careful when we use words like sovereign function to interpret a democratic constitution, a constitution which sets up a republic, and a constitution which has Part 4. Now, my lord, I'll just read further. It said judgment, the effect reads as follows. The relevant constitutional entries speak of industrial and labor disputes. Entry 22, list 3, schedule 7. The preamble to the act refers to the investigation and settlement of industrial disputes. The definition of industry has to be decoded in this background, and our holding is reinforced by the fact that industrial peace, collective bargaining, strikes and lockouts, industrial education, workers' committees of employers and employees, and the like cannot organize systematic operations and collectivity of workmen cooperating with their employers in producing goods and services for the community. Triple test. The betterment of the workman's lot, the avoiding the outbreak and blocking production in the interest of the public, other concern of the community. In trade and business, goods and other services are to be common for the community, not for self-consumption. Again, my lord, an answer to my Lord Justice question on what is excluded, what is for self-consumption. Over here, again, there's an answer. Now, my lord, then of course I've said it is submitted that when we read the preamble of the act and the objects to be achieved, the decision in Bangalore supply is good law and does not require reconsideration. The word industry must be interpreted not only in the light of the object of the act, but also in relation to the definition of workman, industrial dispute. It is further submitted that Bangalore Water Supply interpreted the definition of industry with reference to Part 4 of the Constitution. It is also held that the decision that even though the statute is a pre-constitutional enactment, it must be interpreted in the light of Part 4, and there's a quotation there. The penumbral area arrives as we move on to the other essentials needed to take an organized systematic activity oriented on productive collaboration between employers and employees and industry as defined in Section 2J. Here we have to be cautious not to. Now, my lord, this is very interesting. This is the actual guidance, what my lord was asking, Justice Narasimha. Definitional expansionism, broadening on reductio ad absurdum, to truncate the obvious amplitude of the provisions. What the court is saying is we can't fall into both traps. We cannot widen it too much. We cannot narrow it too much. Subjective wish shall not be father to the forensic thought. If credibility of a pluralist community is a value to be cherished, court is saying we have to be just to both sides. Now, courts do not substitute their social and economic beliefs for the judgment of legislative bodies. See, Coven, even so, this legislation has something to do with the social justice between the haves and the have-nots. Does it or doesn't it? My answer is yes. It has something to do with the haves and have-nots. And naive, fugitive, and illogical cutbacks on the import of industry may do injustice to the Benegant enactment of. Now, my lord, this required me to get a dictionary, but I will tell you what this means. It's very interesting, my lord. He's referring to two Greek monsters, avoiding silica and Carabalus. We proceed to decipher the further import of the. Now, my lord, these, when I looked it up, I found that these are two monsters on the side of a river. One is clinging to one side, one is clinging to the other side. And there is a ship that is navigating between these two monsters trying to pass through. If you go too much on one side, one monster will catch you. If you go too much on the other side, the other monster will catch you. So Justice Krishna is saying, my task is difficult. I have to avoid the overbreadth. I have to avoid the over-narrowing. And I have to navigate my ship between these two. And that, I submit, is what Bangalore Water Supply has done. We proceed to decipher the fuller import of to sum up the personality of the whole statute, be it remembered, has a welfare basis. It being a beneficial legislation protects labor, promotes their commitment, and regulates situations of crisis and tension, where production may be imperiled by unattainable strikes and blackmail lockouts. The mechanism of the act is geared to conferment of regulated benefits to the workman and resolution, according to a sympathetic rule of law, to the conflicts, actual or potential, between management and workmen. Its goal is ameliorative of the conditions of the workers, tempered by a practical sense of peaceful coexistence to the benefit of both, not a neutral position, but restraints on laissez-faire and concern for the welfare of the weaker lot. Empathy with the statute is necessary to understand not merely its spirit, but also its sense. One of the vital concepts on which the whole statute is built is industry. And when we approach the definition of Section 2J, we must be informed by these values. This certainly does not mean that we should strain the language of the definition or import into it what we regard as desirable in an industrial legislation, for we are not legislating de novo, but construing an existing act. Crusading for a new type of legislation, dynamic ideas of humanist justice and industrial harmony cannot be under the umbrella of interpreting an old, imperfect enactment. Nonetheless, statutory diction speaks for today and tomorrow. Words are semantic seeds to serve the future hour. Moreover, and earlier highlighted, it is legitimate to project the value set of the Constitution, especially Part 4, in reading the meaning or even the pre-constitutional statutes. This is the authority, my lord, for the proposition that pre-constitutional statutes also must be held to this standard. The paramount law is paramount, and Part 4 sets out directive principles of state polity which must guide the judiciary. Like other instrumentalities in interpreting all legislation, statutory construction is not a petrified process, and the old bottle may, to the extent language and realism permit, be filled with new wine. Now look at the last sentence. Of course, the bottle should not break. So, Bangalore water supply has not broken the bottle.
Last line, the bottle should not
Yes.
break and lose shape.
So, my lord, the triple test in Bangalore water supply has been spelled out based on the object of the act, etc. That I've already told my lord. Kindly turn to the next page.
Shamindra, the next point we are raising, that probably that you need to enlighten. What is the very next point?
Whether the constant,
That, the consequence of defining
yes,
industry.
my lord, the consequence. I'll come to the consequence. It is respectfully submitted that the only consequence of defining industry in the manner done by Bangalore Water Supply is to provide workmen with a remedy to ventilate their grievances. I've said that, my lord. In relation to fixing of wages, health, safety, occupational safety, security of employment, it does no more, no less than that. A democratic society governed by the rule of law is duty-bound to provide a grievance redressal forum of a judicial nature to all its citizens, where their substantive rights can be ventilated. The Industrial Disputes Act does no more, no less, and hence the law declared in Bangalore Water Supply causes no prejudice to employers other than facing a competent labor court. Then, my lord,
Civil suit you have already explained.
I said that earlier. My lord. Yeah. When I referred to Firestone, this was the argument in Firestone. Then I've said, I'll skip that. I've said it earlier. Filing a civil suit is not a remedy.
Not a remedy. That you have already explained.
Now, my lord, finally, the issue of sovereign functions. The word sovereign function is misplaced in a democratic society. The Honorable Court in Chief Conservator of Forests referred to the inalienable governmental functions. The Honorable Court in Chief Conservator said, we may not go by labels. Let us reach the hub. And the same is that the dichotomy of sovereign and non-sovereign functions does not really exist. It would all depend on the nature of the power and the manner of its exercise as observed by Nagendra Rao in the Nagendra Rao case. As per the decision in the case, one of the tests to determine whether the exclusive function is sovereign in nature is to find out whether the state is answerable for such actions in a court of law. You know, this inspired my proposition that a political question is not answerable in a court of law. I cannot raise a question that the state has no right to go to war. So the learned judge is saying, not answerable in a court of law. Not answerable in a court of law. It was stated by Sahai J that acts like defense of the country, not a minting press when you're going to war. Raising armed forces and maintaining it, making peace or war. Foreign affairs, power to acquire and retain property, function, territory, but not acquisition of territory beyond the borders of Bharat. You can acquire territory or you can cede territory. Those are sovereign functions.
I think the first line of your next paragraph answers everything.
May I move to that, my lord? It is submitted that strictly speaking, sovereign functions are only those which are not only inalienable but are also classically referred to as the political question. Lord, this proposition is culled out from that judgment. As I said, it's inspired by that judgment. Even
Right.
for me, my Lord, even for me, it came as a revelation because I've been wondering why certain petitions are rejected by the court. Till I came to the conclusion that they may be raising political questions which are not justiciable. So I can't come to court and say, why did the country go to war? I will be told it's a political question, not justiciable in a court of law. Those are sovereign functions. So there's an overlap between questions which are political questions and the ones which are sovereign functions. Then, my Lord, in conservator, again, they said the aforesaid shows that if we are to extend the concept of sovereign functions to include the welfare activities, as contended on behalf of the appellants, the ratio in Bangalore water supply would get eroded substantially. We would demur to do so on the face of what is stated in the aforesaid case, according to which, except the strictly understood sovereign functions, welfare activities of the state would come within the purview of the definition of industry, and not only that, even within the wider circle of sovereign functions. The LPG issue comes in here, wider circle. The aforesaid being the crux of the scheme to implement which some of the respondents were employed are of the view that the same cannot be regarded as part of the inalienable, inescapable functions of the state, for the reason that the scheme was intended even to fulfill the recreational and educational aspirations of the people. We are in no doubt that such a work would well be undertaken by an agency which is not required to be an instrumentality of the state. Again, a test. There's a test. Then, my Lord, charitable purpose.
Charitably, you have already.
I have argued, I will,
This you need to, this LPG.
Last one left.
LPG, my Lord, LPG
Yes.
gas is in short supply. I am thinking of filing a petition before you, but I will not want a decision right now saying that I am not getting my LPG gas.
In being
But-
that.
But my Lord, don't give a judgment till I file the petition. Yeah.
But we really liked the short term because I said why LPG has come. Then I realized liberalization, privatization and globalization.
You said yesterday.
I picked it up from Justice Nagaratna. We have a different word for it, but never mind. It,
No, I said that in my reply to the welcome speech when I became a judge in 2008. That as a judge, we now need to, be aware of what is happening globally. In 2008, February 18th, I said it, that liberalization, privatization and globalization is something we should consider while deciding cases.
yes, my Lord.
So I said LPG then.
Without knowing that one day
Acquired a
LPG
new
will be in
meaning.
short supply.
Now it acquired a new meaning.
At that time, LPG was plentiful.
Yes.
Then, my Lord, I want to read this. It is submitted that there has been a sea change in the approach of the Union of India to the question of what should be and should not be governed by functions due to the policies such as disinvestment and the new public sector enterprise policy, which permits the entry of private players in strategic sectors formerly considered sovereign functions. It has been noticed that sectors such as defense, nuclear energy have also been opened for privatization, subject to the limitation mentioned in the said policies. See separate note. I'll just read that short note. It is submitted that the greater the implementation of LGP, the greater the applicability of the Industrial Disputes Act. That is the implication of it.
Next line also, and the
Yes.
greater the nature of activity,
Yes.
that will be gone.
The
by-
greater the nature of the activity will be governed by the definition of industry as laid down in Bangalore water supply. For the reason that the sectors liberalize
This is 39.
these to be.
Exclusively government fund.
Give me that LPG thing, please.
This is the one.
Applicable.
Applicable.
Applicable. No, the greater the LPG, the greater the applicability of the Industrial Disputes Act. That is my submission, my Lord. Then, my lord, my lord, just 1 minute. I will just read a short note which I've circulated on what are the sectors that are being liberalized. It's already there on the record, a note. What is the Indian government's approach to privatization? That is the heading. First, they have published a disinvestment policy. It's all I'm reading from policy. Is the document there? No, it's part of the submissions. Just conclude the submissions and turn over. You'll find a note. What is the Indian government's approach to privatization? All this is taken from official sources. First thing is the disinvestment policy consists of strategic disinvestment, entire substantial sale of government shareholding in central public sector enterprises, and transfer of management and control. Privatization is subject of strategic disinvestment where the government equity in CPSE and its management control is transferred to a private strategic buyer. Minority stake sale carried out without the transfer of management and control, though various SEBI approved methods such as inter-public office, office for sale, buyback of shares, etc. Next, new public sector enterprises policy. Atmanirbhar Bharat, the policy intended to minimize the presence of government in the PSEs across all sectors of the economy. Strategic sectors. It delineates 4 strategic sectors based on a criteria of national security, energy security, critical infrastructure provisions of financial activities and availabilities of important minerals, aims for a limit of 4 PSC of the holding nature of strategic sectors. Next, my lord. Strategic sectors will remain under government control, bare minimum presence of the existing public sector commercial enterprises at holding company level. The remaining will be considered for privatization, merger or standardization with another PSC for closure. The identified strategic sectors are atomic energy, space, defense, transport, telecommunication, power, petroleum, coal, and other minerals, banking, insurance, and financial services. Non-strategic sectors. All PSCs will be considered for privatization where feasible or closure. Exclusions. The policy does not apply to certain classes of public sector entities, namely not-for-profit companies. CPSE, providing support to vulnerable groups for having development promotional roles. Updates. After the budget of 2025, Honorable Minister Mr. Nirmala Sitharaman highlighted that privatization remained a cabinet-based commitment that will have to be kept up with. At Budget 26, Minister Sitharaman stated that all previously approved disinvestment will continue. Disinvestment and closure of public sector units.
I think you come to my question.
I don't understand. Yeah, I have to read it. I'll tell them to read it.
And by showing that
Last.
But not only one more thing to read, the Shanti Bill, where even nuclear energy, some parts of it are being privatized. It's there in the document. I will not read it. Enables limited privatization in the nuclear sector.
This information which you have brought on with the note is only for our consumption to understand that.
Only for understanding that they are not sovereign functions, only for understanding how not to interpret sovereign functions, and also why not to take away these sectors from the protection in the name of sovereign functions, Milord. So, Milord, actually
included all the 3 states in sovereign function.
Now, Milord, that is why I said the danger of the interpretation in the new act uh, they have used an inclusive first of all, they have not defined charitable purpose. Secondly, they have not defined what is a social purpose. Thirdly, they have not defined what is philanthropy. Fourthly, they have not defined what is a sovereign function. But by way of illustration, they have said space, atomic energy, and defense.
No, this policy should.
That's the three sectors which they identify as sovereign functions. There also my submission is, yes, they are sovereign functions, but at the level of decision making. That is why the doctrine of severability, where Chandrachud says if there's a mint, when you're coining, producing coins is a government function. You can't, a private person can't do it. But a worker in a mint, that can be separated from the function, from the sovereign function, and that person can be given the protection, is given. They're all the mints in India are registered under the Factories Act, all of them. Then how does it lie in their mouth to argue? Huh? Trimurti? Which Trimurti judgment? That alone I've given that judgment. That is a judgment which takes the view that it's a bench of 9.
That compilation you have already.
My lord, I have a written submission which was originally filed. I will not trouble you by reading it. It's on the record. As I said, I've made you 2 submissions, one before listening to them and one after listening to them. So the one which I've read out is the one which is after listening to them, but the one before listening to them is also on the record.
That's-
I will only request you to read it. I will not trouble you with it.
Well, they're on record.
My lord, only one last thing, my lord, there's an interesting quote in, and I will stop with that. No more quotes by Justice Krishna Iyer, but this one is a must. My lord, on the question of charity, the argument was that for us it's a mission. We are doing a mission. For me, it is a mission. For example, if I say for me, doing legal aid is a mission. In other words, a passion. So Justice Krishna says, and please read that one sentence, it's really worth reading. He says, all of life is a mission. And a life without mission is a stillborn life. Well worth reading, my lord. At least I took that statement to heart and I use it in my professional work. Thank you.
Thank you. Thank you very much. Yes, Mr. Singh. Only left a point. So, Madam Indra has very exhaustively explained.
अरे नहीं रे, come.
Okay.
Come.
Sorry. Lords, I'm appearing for the Federation of Unions New Trade Union Initiative, which is one of the few nationwide.
For us, broadly, all of you are representing workers, whether federation.
No,
individual-
I only want to point this. I only want to point this out in one sentence. This is one of the few nationwide federations with more than 10,000 members, which is completely non-political. It is by constitution, it is not allowed to align with any political party or any political dispensation. So it's a completely independent federation, only works with the workmen. Now, I'll just break up my arguments into 4 Lords, broad areas, and I'll just delineate them or outline them for your Lordships. The first is, Lords, on a practical level, whether, Lords, this exercise, which your Lordships are very painstakingly taking up by learned 9 judges bench, whether it can yield, Lords, a fruitful or, Lords, a workable outcome. So the first, I'll be very brief on that, on the practical aspect. Then, my lords, on the 5-judge bench, because the only bench which has actually made the reference, my learned friend Ms. Jaising has rightly pointed out about the lack of any justification with regard to conflicts between 2-judge benches and all. But ultimately, the reference has been made by a 5-judges bench, and the 7-judges bench, before whom we all opposed, bumping it up further one more step. The learned 7-judges bench has just said that it's an important question of law arise, and the 5-judge bench has given reasons, therefore we bump it up. Their lordships in the 7-judges bench have not It's a 1.5 paragraph order.
See, that's why we yesterday also indicated. Now we are not going to in history.
No, I'm,
The mistake started after Safdarjung or it.
no, not on
after
the,
what?
no, I'm going to point out that the issues flagged, the 4 issues flagged by the 5 judges bench are not issues at all. They don't arise either from Safdarjung or from Millard's Bangalore water supply. I need to place that before Lord. That's the second limb.
We are only assuring that since 9 of us are sitting, we are keeping our hope alive that it will do some meaningful job.
Yes, absolutely. Milord. We want ultimately, Milord, any outcome for to be a productive and workable outcome. I have Milord, some and it's a practical thing which I'll place before Lordship in a moment.
But tell us that.
May I start with it? My Lord wants me to start. The other points I'll come to later. So yesterday,
To indulge in some industry.
absolutely, Milord. But
We are industrious.
I'll tell you, Lordship, what the difficulty is. I'll play. It's a practical difficulty. It's a difficulty. It's not that we want to create a hindrance for the bench. It's a difficulty as to what we foresee, what can come out. And I'll tell you, Lordship, what it is in a moment.
See, frankly speaking, you need not to carry this burden. Reason let me tell you as Chief Justice, I have 2 matters, 9 judge bench matters, then I have 21 7 judge matter. And my endeavor is that one by one, all these matters will be finished.
My Lord.
So what would be the outcome? That's a different issue.
No,
because
so let me
Merits of the matter.
just outline that in a moment, Lord.
because of the larger benches, some matters in the high courts are pending, in district courts are pending. So this pendency here, a reference to a question of law, whatever may be the answer, we are not concerned about that.
Quite so.
It will
So let me.
pay for the disposal.
In the normal course, there would be no problem. Let me just outline it. The reason why I intervened before the matter began yesterday was not on a casual basis. I'll tell you, Lordship, why. We have a judgment which has held the field for 48 years, based on which a large number of matters have been decided, have become final, have either been decided and attained absolute finality, or, my lords, they have been decided at various levels. For instance, Mr. Nafde and I oppose each other in the Bombay University matter, which are pending here. Now, there, my lords, since 1990, and I'll just take a moment for this because it will tell your lordship what is the practical difficulty. Since 1990, say 938 people were kept on casual basis with artificial breaks, etc. 2017, the Industrial Court of Maharashtra rules that this is an unfair labor practice basis the evidence of the university, long oral evidence, etc., where they admit completely that these are permanent posts, they're doing permanent work, etc., that it's an unfair labor practice and directs them to be made permanent. Single judge of Bombay High Court affirms, division bench of Bombay High Court affirms, matter comes before your lordships, and because this question was pending, this gets tagged here. Now, therefore, meantime, my lords, on 2nd of February 2026, the act comes to be repealed. Now, I'll show your lordship section 104 of the code and section 6 of the General Clauses Act. And with the effect of that, your lordships will see that the effect is that your lordships will now have to see any decision which your lordships give on a repealed statute will, number one, it will have to be prospective. Whatever interpretation your lordships place will have to be prospective because you can't reopen matters which have already been decided.
I think let's start on merit.
Yes.
This issue will leave to us. We have applied in 100 times in the past, we have applied doctrine of prospectivity where we found that.
But here, prospective in a repealed statute.
No
There's a difference.
No question of repeal. Repeal is only in 2025. Your cause of action, your adjudication is all prior thereto. If we find.
So just see section 104.
If we find that Bangalore water supply was correctly laid down, there is no question of retrospective.
No question of interference.
It is only if we find that there is something wrong with that judgment.
Yes.
Then question of prospectivity come. Then this doctrine has been 100 times applied by this court.
I see that, but it is applied in repealed statutes only in revenue matters.
If you want to argue against yourself, then we can't stop you.
No, not at all. I'm not arguing against myself.
Does the question arise at all?
This question doesn't
What
arise at
our
all.
interpretation will apply to the cases which have arisen under the Industrial Disputes Act. And it is, we are redefining that.
They are pending at whatever
They are pending.
stage of the
They're only-
hierarchy.
Plus, where evidence has
Pending cases, it will apply.
matters where evidence has already been led, matters have been decided at certain levels. It may be pending in the Supreme Court.
Finality.
It may not have attained finality, but look at the consequence of, suppose the court were to take a view that the whole proceeding is without jurisdiction. Do we set the clock back? Evidence-led, judgments of courts, etc., will your lordship set the clock back? So I'm only saying, I'm drawing your lordship's attention to section 104 of the code, which is the repealing provision, and section 6. I'll just place it, Lord. I'm not.
Your last argument based
Very well.
purely on equitable principles.
So now let me
In
come.
case we take a view contrary to Bangalore Buds,
Violence.
in that event, we should follow the doctrine of prospectivity.
Yes,
Because the hopes,
absolutely.
the relief, the benefit, if for decades the laborer, the workers have got it,
Mileage.
we should not take away it.
I'll withhold that. I'll come and
That argument we already taken note. Now
let me come to it at the end. Now let me come, Lords, to the first reason why your lordships ought not to, Lords, re-examine Bangalore Water Supply and Sewerage Board. Now, your lordship, we did a search. My instructing counsel, Lord, I must say, with great diligence, have done a search of the Supreme Court cases. And Lord, my written submission, my written note, my Lord may just note in volume 2, pages 1 to 22 is the note.
122.
No, page 1 to page 22. Page 1 is the note.
Yes.
My Lord may
Yes.
take it. Volume 2, page 1.
Yes, got it.
Now, at page 4, para 5, and I'll just point this out to your lordships.
According to an SEC search.
Yes. According to an SCC search, my lords have that, Ms.?
Yes.
According to an SCC search for Bangalore Water Supply and Rajappa, the judgment has been cited in at least 84 Supreme Court cases and at least 898 High Court cases, including all High Courts except Jammu and Kashmir. At least 31 judgments, now this is the Supreme Court, at least 31 judgments clearly follow or approve of BWSSB in a labor law context. Another 20 approve of it in the context of principles of statutory interpretation. I may just pause here. So 51 out of 84 follow it and approve of it, either in the labor law situation or on statutory interpretation laws. Only 5 appear to question BWSSB. Of these, 1, Bombay Telephone, has been overruled.
Yes.
1, Coir Board made a reference for reconsideration, which was later refused. Coir Board was, my lord, Her Ladyship Justice Sujata Manor's order, which the 3-judge bench said there's no case for reference. 2 other orders passed in the present proceedings. That is the Jaybir Singh proceeding. And the last, Physical Research Laboratories, only seems to apply BWSSB incorrectly and notes that BWSSB is not exhaustive on the question of sovereign functions. Another 10 distinguish BWSSB, and the remaining 18 either cite or refer to BWSSB in varying contexts, but do not materially engage with the judgment. I checked. The 10 which distinguish it not on merits, but distinguish saying it's not applicable to the argument which is being advanced in those particular cases. So 84 times the Supreme Court engages with this judgment, 51 times cites it with approval. I'm just placing this in this 48-year period. This is the actual, the sort of proof of the pudding, so to speak, because we hear a lot of doubts which are voiced about how it has worked, some deleterious consequences and so on and so forth. This is the actual record for the last 48 years. Now, my lords, the main, there are 4 grounds, my lords, which are urged in the 5 judges bench. Lord, I think his lordship Justice Dharmadhikari speaking for the bench, gives 4 main grounds, and we've engaged with those specifically in this note, my lords. So the first reason, Lords, if your lordship sees page 1 of my note, it just summarizes those 4 points, but I'll straight away go to the reasons themselves, my lords. The first reason, my lords, is that Bangalore Water Supply inhibited Parliament or the executive from enacting or notifying an amendment to Section 2J or bringing a more expansive or more restrictive definition to demonstrably, this is demonstrably wrong as a matter of fact. In fact, in 1982, your lordships are aware, Amendment Act, Hospital Act was enacted, etc. But when the Parliament found that there was great opposition to having separate laws,
This reason you can ignore, I
Yeah.
think, because 82 amendment was after this, they didn't notify it.
and now the 2020, so this that is the first reason.
Yes.
The second reason, my lords, is that Bangalore water supply was confined only confined only such sovereign functions outside the purview of industry, which can be termed strictly as constitutional functions of the three wings of the state, that is executive, legislature, and judiciary. Now, this, my lords, in my humble submission, Bangalore water supply actually, as fell from my Lord Honorable Justice Narasimha, actually narrows down the scope of the plain words of Section 2J. 2J has no intrinsic curb in it against sovereign, covering sovereign functions. The Supreme Court, finding that there might be certain areas which should be sort of no-go areas where the functions of that particular undertaking would be such that they ought to be kept outside the sphere of court interventions or certain protections to the workers, etc., etc. It is a narrowing down which was done by the court in Bangalore water supply. But what is important here is that the sovereign function test, Bangalore water supply, actually enlarges what is available for sovereign functions from superintendent and legal remembrancer, which was a 9 judges bench, lords, and I want to straightaway take your lordships to that judgment, lords. Before going further, let me straightaway take my lords to superintendents and legal remembrancer, lords. Your lordships will find that judgment, lords, is in volume 5A,
Yes, serial number?
look, this is volume 5A, page 1426. 5A, page 1426. It is PDF 1439, page 1426. Sorry?
Serial number 57.
Serial number 57, I'm told, in the index of volume 5A.
Nine judges.
9 judges. So, the first para may just be read, Chief Justice Subbarao speaking for the bench. This full bench, may I read that?
Yes, yes.
This full bench of 9 judges has been constituted to consider the correctness of the decision of this court in Director of Rationing and Distribution versus Corporation of Calcutta. The relevant facts are set out, but basically what happened was a penalty was imposed for violation of municipal licensing laws against the municipality. And the issue was that can the sovereign be levied penalty under a state law? And that is set out in para 2, my lords. Now, if your lordships are kind enough straight away.
There are two questions, arguments.
You didn't take a license to run a market.
Yes, the two, para 3, I'm grateful to your lordships. Learned Advocate General of West Bengal raised before us the following points. 1, the state is not bound by the provisions of a statute unless it is expressly named or brought in by necessary implication. 2, the said principle equally applies to sovereign and non-sovereign activities of a state. And Mr. N.S. Bindra, Learned Counsel appearing for the Attorney General, raised before us the third point, namely, this court has no power under the Constitution to review its earlier judgment. Now, just give me the paras now.
Para 9.
If my lords come to para 9, yes. Lord, I must clarify, Lord, the Learned Chief Justice Subbarao was speaking for 7 judges, Lord, in this judgment.
There's one concurring opinion.
There's one concurring opinion and one dissenting opinion. In Justice J.C. Shah dissents, and Lord, there's a concurring opinion of Justice Bachawat at the end. Lord.
So begin at page 1430, para 8.
Lord, para 9, if may I read para 8, my lords, at page 1430, Frankfurter J said to the same effect. This is after setting out Bhasham Iyengar and municipal commissioners for the city of Madras. After that, para 8, Frankfurter J said to the same effect in United States versus United Mine Workers of America. At best, this canon, like our other generalities about statutory construction, is not a rule of law. Whatever persuasiveness it may have in construing a particular statute derives from the subject matter and the terms of the enactment in its total environment. Even in England, this rule of interpretation has not been treated as inflexible. It is gradually losing ground in many branches of law. The incongruity of the rule of discrimination in favor of the Crown was pointed out by Glanville Williams in his treatise on Crown proceedings. The rule originated in the Middle Ages when it perhaps had some justification. Its survival, however, is due to little but the vis inertiae. The author continues at page 54, with the great extension in the activities of the state and the number of servants employed by it, and with the modern idea expressed in the Crown Proceedings Act, compare in this connection Article 300 of our Constitution, that the state should be accountable in wide measure to the law. The presumption should be that a statute binds the Crown rather than that it does not. The next question is how far and to what extent the common law of England relating to the prerogatives of the Crown has been accepted as the law of our country. Nothing has been placed before us to show that the entire body of the common law pertaining to prerogatives was accepted as the law throughout India. India at the relevant time comprised provinces and native states. As Bhasham Iyengar J pointed out in Bell versus Municipal Commissioners for the city of Madras, the prerogatives of the Crown in India, a country in which the title of the British Crown is of a very mixed character, may vary in different provinces, as also in the presidency towns as distinguished from the Mufassil. The determination with anything like legal precision of all the prerogatives of the British Crown in India is by no means an easy task. It is well known that the common law of England was applied as such in the original sites of the High Courts of Calcutta, Bombay and Madras, and that in the Mufassil courts, the principles embodied in the common law were invoked in appropriate cases on the ground of justice, equity and good conscience. It cannot therefore be posited that either the entire body of common law of England relating to prerogatives of the king or even the rule of construction as forming part of the common law was accepted as law in every part of the country. It has to be established whenever a question arises as to what part of the common law was accepted as a law in a particular part. Just give me yours. This is frozen. Para 16, my lord. Don't make their lordships read everything. Just come to the relevant part.
There's 7 or 8 lines of para 19 in the last will throw some light. Rest is all reference to the UK law.
Just para 16 may be seen because their lordship said that wherever exemptions were to be granted, they were expressly granted.
Probably what you want to argue is partly summed up in 7, 8 lines of para 19.
Para 19, I'll come
After
straight there.
entering to US, UK and domestic law.
Yes. But, afterwards,
You can start the same rule was again.
the same rule was at page 1436. The second part of the same rule was again restated in United States of America versus Reginald Wittek. The question there was whether the District of Columbia Emergency Rent Act did not apply to government-owned defense houses in the district, such as Bellevue houses. The court relied not only upon the said rule of construction, but also on other circumstances in support of the conclusion that the United States was exempt from the operation of that act by necessary implication. In Jess Larson, etc., the purchaser of surplus coal from the War Assets Administration filed a suit against the said administration for an injunction prohibiting the latter from selling or delivering coal to any other person. The suit was dismissed on the ground that the sovereign immunity in suits for injunction or for specific performance was based upon public policy. But it was argued that the principle of sovereign immunity was an archaic hangover, not consonant with modern morality. The majority conceded that there was substance in such a viewpoint as applied to suits for damages. Mr. Justice Frankfurter in his dissent went further and pointed out that the doctrine of sovereign immunity was in disfavor. The American decisions, therefore, were mainly based either on the provisions of the Constitution of the state or on the ground of public policy evolved by the courts. The founding fathers carried with them the English doctrine of the crown prerogative, and it continued to influence some of the principles of public policy evolved in that country. Even so, the decisions made it clear that the rule of construction was relied upon only as one of the guides to arrive at the intention of a particular statute. That apart, the fact that the common law of England pertaining to prerogatives influenced some of the decisions of the Supreme Court of the United States cannot help us in coming to a conclusion whether the said rule has become part of the law in India. And then was paragraph 22. Their lordships now say, let us now proceed on the assumption that it has been accepted as a rule of construction throughout India. This leads us to the question whether the said rule of construction is the law of the land after the constitution came into force. Under Article 372, all the laws in force in the territory of India immediately before the commencement of the constitution shall continue in force therein until altered or repealed or amended by a competent legislature. Now, can I come straight to the last 5 lines on this page? But it is not possible to hold. Because I'm just skip over, but it is not possible to hold that a mere rule of construction adopted by English courts and also by some of the Indian courts to ascertain the intention of the legislature was a law in force within the meaning of this term. There's an essential distinction between a law and a canon of construction. This distinction between the law and canon of construction has been noticed by us earlier, and we have held that a canon of construction is not a rule of law. We are not concerned here with statutory rules of interpretation. We are therefore of the opinion that a rule of construction is not a law in force within the meaning of Article 372. Then their lordships dealt with the Privy Council in para 24, my lords may straight away come. There is therefore no justification for this court to accept the English canon of construction, for it brings about diverse results and conflicting decisions. On the other hand, the normal construction, namely that the General Act applies to citizens as well as to the state, unless it expressly or by necessary implication exempts the state from its operation, steers clear of all the said anomalies. May I just repeat that? The general law applies equally to citizens and to the state unless it expressly or by necessary implication exempts the state from its operation. This would steer clear of all the said anomalies. It prima facie applies to all states and subjects alike, a construction consistent with the philosophy of equality enshrined in our constitution. This natural approach avoids the archaic rule and moves with the modern trend. This will not cause any hardship to the state. The state can make an act if it chooses, providing for its exemption from its operation. Though the state is not expressly exempted from the operation of an act, under certain circumstances, such an exemption may necessarily be implied, which is what Justice Krishna Iyer has done. He has found an implied exemption for that narrow part of inalienable sovereign function. We therefore hold that the said canon of construction was not the law in force within the meaning of 372. In this view, it is not necessary to express our opinion on the question whether the aforesaid rule of construction would not apply to the trade activities of the state, even if it applied to sovereign activities. And then, at para 30, I think we can skip over that.
Just the concurring opinion, paragraphs 54, 56.
That's good enough to
And the
understand.
concurring opinion is set out now that paragraph
4, 55, 56.
paras 54, 55, and 56. That is Justice Bachawat's opinion. Very brief opinion is at the end of this. Paras 54 to 56.
We have seen that.
Yes. So this was the 9 judges bench, which takes a view which, though it was not in the context of Industrial Disputes Act or law, but the view here, the view in Safdarjung Hospital is directly contrary to this. Safdarjung Hospital says basically, if it's a private hospital, it's an industry. If it's a government hospital, it's not an industry. Just on the basis, on the footing, that if it is set up by the government, it stands outside. It goes on the assumption of a sovereign immunity.
Yes, we can continue. I think your 4 points we can.
No, on this aspect where I wanted to point out. So this was the second aspect of the reason why this Bangalore water supply needs to be re-examined. There are 2 more points, I can continue tomorrow if your lordships.
You see, we have time constraints because that's why we allocated time and we have requested now to amicus. We need to give some time to them.
Yes, yes.
So please, we'll request you that if you can wind up.
But I'll need a little bit of time because there are 2 more. Apart from this, I need to show your lordships on the act itself, because nobody has shown your lordship. There are very general statements have been made that there are many protections available. Now, for instance, my learned friend, Mr. Shahzad Farasat, said in his note for State of Punjab that there are Shops and Establishments Act, West Bengal Act, Delhi Act, etc. Now, I need to just give your lordship a bit of outline here. Industrial law in India has many facets to it. The law dealing with the employer-employee relationship, that is,
Other statutes can't cast any shadow on the ID Act. I think that we are very clear about it. whether it grants big relief or it grants small, whatever it grants, it grants. The only question is that we are only trying to identify who are entitled to that protection.
Yes, yes. So
Area, not that what kind of protection it grants. I think that.
No, not that. But I need to take your lordships through the ID Act and also show that what the ID Act provides for is not available under state laws. What the, say the Factories Act, for instance, which is a federal law. The Factories Act provides for safety and health, primarily. Working hours, safety and health.
Right, that is-
Because they came from a particular
Minimum Wages Act only provide minimum wages.
minimum wages. Payment of Wages Act provides for the mode of payment of
Recovery
wages.
That we understand.
But suppose I'm not paid wages, I can file a complaint and I can get my wages. But if I'm not paid wages and I claim wages and I'm sacked because I claim the wages, I can't get my job back under the Payment of Wages Act.
Just now, Madam Indra argued that we were explaining at that time 11A, power of 11A.
Yes,
This power is not available under any other statute.
that's right.
That is only specially to this statute.
That's right.
Like power to go on strike, power to declare lockout, all these, of course, subject to conditions of like industrial establishment conditions are different. In the case of industrial public utility, the conditions are different. Section 22, Section 23.
Yeah. No, so for the coverage of industry, I just need to show your lordships, not the act itself, because as rightly Lord posited by my Lord Justice Datta, that when even if you're looking at an interpretation clause, you cannot look at the clause alone. You have to look at it in the context of the act. So now let me place the act before your lordship.
Said that you have to see the entire statutory scheme.
That's right. So there are two more points on this reference order, which I'll show your lordship.
Yes,
But
yes.
let me first place the act, my lords. Now, if your lordship come to the Industrial Disputes Act for a moment, in volume 4, but that page 53 in volume 4, my lords. Lord, I think if your lordship could take the Bare Act, it would be better. Because that's what has been put there.
Estimate. 45 minutes, because we have to here to learn by us.
Yeah.
So,
I would need half an hour, Lord.
then what about your colleagues?
No, the question is, Lord, that ultimately,
10 minutes each, that's all.
no, my difficulty is, Lord, that I have to place before your lordships 4 or 5 issues which are very important and which
No, how, we can give you
I can only say this, that I would not repeat anything, but it's an important question. Ultimately, if you're
what we want to point out, we know very well the very scheme of the
yes,
act.
yes. So let's kindly come to the act, my lords.
Yes.
If your lordships are kind enough, just to see the Industrial Disputes Act.
Yes.
Mr. Singh, what do you want to point out in the act?
Yes. So if my lord will first need to see the definitions. But first, please see the definition in 2G of employer.
Yes.
I'll come back later to 2A with regard to appropriate government, but please see just 4 definitions are very important to be seen in conjunction. 2G, 2J, 2K, and lots 2N. These need to be seen in conjunction. So 2G, employer means in relation to an industry carried on by or under the authority of any department of the central government or a state government, the authority prescribed in this behalf, or where no authority is prescribed, the head of the department. In relation to an industry carried on by or on behalf of a local authority, the chief executive officer of that authority. That's the end of the definition.
Yes, that's it.
So, in employer means an employer in relation to departments of government and local authority. Private sector employer is not defined here because it is taken in common parlance that who is the employer is known.
Because private
Now,
sector-
there's the reason I'm pointing this out. For anybody to even attempt to argue that the government is exempt, as was done and as was held by a learned 6 judges bench in Saftarjung, in the teeth of a definition which only applies to government and only applies to municipal corporations. If you take the normal interpretation that means is exhaustive, the solitary.
That makes sense.
That means the private sector employer is not an employer at all, if you were to take that literal rule of interpretation. Now 2G, now you kindly come to
Any
2J,
Department of the government. Any Department of the government.
any department of the government. Yeah. Yeah. Now come to 2J, your lordships have seen industry.
Whether it is central or whether it is
That
state.
is the distinction. Central or state, that for
So,
that appropriate
yes.
government.
Now
With
come,
regard to an industry,
yes,
there again we come back to that very
Carried on.
same question.
no, industry carried on by or under the authority of.
Means government.
So if it's
Central government or state government?
state government or central government, if the industry is carried on by or under their authority, then who is the employer is defined. And in relation to any industry carried on by on behalf of a local authority. So all your sewerage, this, that, etc., that is by Bangalore Water Supply and Sewerage Board, etc. Then Lord, industry, 2J, industry means any systematic activity carried on by cooperation between an employer and his workman, whether such workmen are employed by such employer directly or by or through any agency, including a contractor, for the production, supply or distribution of goods or services with a view to satisfy human wants or wishes, not being wants or wishes.
You're reading the 1982. You're reading the 1982
Oh,
amendment.
sorry, there's a new one. Why is the new one here? Why have you handed me the new one? My learned has handed me the wrong statute. Sorry, industry, the original definition, industry means any business, trade, undertaking, manufacture, or calling of employers, and includes any calling, service, employment, handicraft, or industrial occupation or avocation of workmen. Now, industrial dispute in 2K says, industrial dispute means any dispute or difference between employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment or terms of employment or with the conditions of labor of any person. Then industrial establishment or undertaking was defined later on by an amendment in 2KA. In the 1982 amendment, this was brought into force. The definition of industry was not brought into force. And this 2KA takes into account situations where there's an undertaking, part of which is an industry and part of which is not an industry. And a dominant purpose test would apply as to whether the whole is an industry or not in 2KA. Then kindly come to 2N, which my learned friend Ms. Jaisingh showed your lordships. But read 2N with 2G, the definition of employer in 2G and 2N. 2N says public utility service means any railway service or any transport service for the carriage of passengers or goods by air, any service in or in connection with the working of any major port or dock, any section of an industrial establishment on the working of which the safety of establishment or the workmen employed therein depends, any postal, telegraph or telephone service, any industry which supplies power, light or water to the public, any system of public conservancy or sanitation, any industry specified in the first schedule which the appropriate government may, if satisfied that public emergency or public interest so requires, by notification in the official gazette, declare to be a public utility service for the purposes of this act for such period as may be specified in the notification. Now in 2N, my learned friend Ms. Jaisingh showed your lordships that all kinds of industries which are, including those which are sort of run, quote unquote, by the sovereign, are included either in the original schedule or by amendment brought in by the government.
That we have already taken note of that.
Yes, but the reason for this is that please see section 22. See the enormity of that argument. Section 22 says that if there is a notice of strike in a public utility service, then under section 12, the conciliation officer shall immediately admit it in conciliation. In all other cases, if there's a notice of strike in a non-public utility service, he may admit it in conciliation.
Exactly. That is-
Now, why he
Yes.
shall admit it in conciliation? Because the scheme of 22, 23 and 24 is that the moment it is admitted in conciliation, the strike becomes illegal and it is banned. So you cannot embark. So when a strike notice is issued in a public utility service, on the issuance of the notice, it's admitted, he shall admit it under section 12 in conciliation. And this is something to serve the nation. This is something to protect the nation because public utility services are seen as essential services, services which have to do with.
You already pointed out, that is the.
So,
That's why.
no,
there is a difference in 22 and 23.
but look at that, not as a definition, not as a cold, just as a cold list. But what is the purpose of that? The purpose is section 22, 23, 24 read with section 12. The purpose is to avert the possibility of disruption of services in the country. So, which is why we need to look at this act as a whole. And then in that context, when Justice Krishna Iyer and the other judges, and I am going to show your lordships that it is not a 5-judge majority. It is a unanimous judgment of 7 judges. There is no dissent. I'm going to show that to your lordships.
In short is, they have a power of bargaining, which will not be available if they are taken out of the purview of the act.
They have the power of bargaining and they have an umbrella under which, with a peace and quiet, they can bargain without disrupting the nation. So they are bargaining with a sort of an umbrella of the state overseeing the state becomes like the United Nations. And instead of going to war immediately and dumping bombs on some country, you first have to go to the United Nations, which tells you, sorry, you can't start throwing your bombs on the employer. First, you have to sit with the employer in conciliation, where it's a public utility service. So there is a whole scheme in this.
We understand well.
Yeah, yeah.
What will be your next argument?
So as far as yes.
We understand the scheme
Yes.
of the act.
Yes. Now, the next aspect, which is there, let me straight away take your lordship to that, which I consider very crucial here, because the whole in Jaybir Singh, the learned 5 judges bench goes on a basis by sort of trying casting a doubt on the formulation and the manner in which a judgment was delivered, and saying that because 3 judges said this, 1 judge said that, somebody wrote. So I want to show your lordship straight away. This is a unanimous judgment because please see what is the dissent.
You can clarify, that's why we persuaded Madam Indra also need not to address on this issue of maintainability, etc.
No, not on maintainability.
Now,
I'm on the need for.
the argument is that probably that the judgment is not by 5-2, it is a 7-judge unanimous judgment.
Yes.
For that you are referring to para 185, Justice Jaswant Singh judgment, where his lordship says rest of the issue not only doubtful area.
No, let me just formulate it. Let me formulate it without even troubling your lordships to open the judgment. Now, on 21st of February 1978, whatever, or 22nd February 1978, 7 learned judges sit in this honorable court and pronounce a judgment in open court as per 145, Article 145 of the Constitution. In the pronouncement, there are 2 judgments, which are 2 opinions, which are fully formulated opinions which are pronounced. One is Honorable Justice Krishna Iyer speaking for himself and 2 other learned judges. So 3 out of 7 judges, there's 1 opinion, which is Justice Krishna Iyer's opinion. Chief Justice Beg's opinion, which I'll show your lordships, is absolutely in concurrence on every single material aspect and says so, and including in the opinion. Though he says that I wish I had more time to elaborate more on certain aspects, that is his fervent desire that if had I had more time, had I not been hanging up my shoes tomorrow, so to speak, hanging up my robes tomorrow, because in the army they say hanging up the boots. So hanging up my robes tomorrow, his lordship, it was just a fervent desire which his lordship is expressing, but fully concurring opinion delivered by the 4th learned judge.
So that's why it is.
Now Justice Chandrachud's opinion is also pronounced at that time along with the other 7 judges, speaking for himself and Honorable Justice Jaswant Singh and Honorable Justice Tulsapurkar, where he says we concur with the opinion.
Yes, we have read that paragraph.
And we agree. No, and the important thing, we agree.
We remember everything. We can tell you in tips. 21st February 1978 is that pronouncement.
Yeah.
It is para 21 and 22. Judgment comes ultimately in April by some understandable.
No, just not that. What I'm saying is something slightly important. What I'm saying is they say that we agree that the appeal of Bangalore Water Supply and Sewerage Board should be dismissed.
Yes, you are right.
Now, when you agree that the appeal should be dismissed, it is not a dissent. We will express our concurrence and divergence of opinion
Later.
but we agree that the appeal will be dismissed. That is a concurrence. A dissent is where you disagree on the outcome. Just because I have some reasons. Now, every day your lordships have judgments of 2, 3, 4, 5 judges, where one learned judge says on a particular aspect, one learned judge may not fully agree with the other learned judges. But they agree in the outcome, but they say that, look, on so-and-so aspect, I have some reservations.
That's why
I have my own
we are
views.
sensitive on this argument. That's why we are accepting what you say.
Yes.
Because that issue doesn't make at all any difference.
So-
on record it is like this.
So it is absolutely and completely a judgment of 7 learned judges, a concurring judgment. There's no dissent at all. That's what I want to put. And when your lordships read Justice Jaswant Singh's opinion, Justice Chandrachud's opinion, in fact, which the additional concurring views which he expresses on 21st April go even further than Justice Krishna Iyer. In my humble submission, his lordship formulates his opinion in even stronger terms, perhaps, than what Justice Krishna Iyer had done. So we have 5 learned judges at least, and 2 learned judges who say we agree, even in the final judgment, again, Justice Jaswant Singh says, we agree that Bangalore Water Supply's appeal has to be dismissed. Right? So on that aspect, the 5 judges, when the 5 learned judges say that this matter should be referred, I submit that they are patently wrong in saying that 2 judges didn't say this and 2 judges said something later and they didn't have access to. So because Chief Justice Beg didn't get to read what Justice Jaswant Singh or Justice Tulsa,
Name the judge by name.
that
The
means,
judgment is
that
judgment,
means
that's all.
nothing at all. And now, Milord, the most important thing is that in your lordships have time and again looked at the issue of when do we overrule or disagree or re-examine a judgment which has held the field for a long time because we are in a larger bench. Now, in the 9 judges bench judgment in Scora, that is the NJAC judgment, Lords, and it's on record before your lordships, and I'll take my lords through that. That is very important. I need to take your lordships through 3 or 4 of the opinions there. Their lordships were invited by the Attorney General, by various other parties, that the second judge's case has been wrongly decided, and that must be referred to a larger bench. And they said that the third judge's case did not go into the whole thing. The third judge's case merely proceeded on the basis that the second judge's case was rightly decided, and therefore the matter must be referred to a larger bench. Justice Kehar, Justice Madan Lokur, Justice A.K. Goyal, Justice Kurian Joseph, and I think one of the other learned judges have gone into this aspect of whether it can be referred at all, and they say in what circumstances should we agree, should the Supreme Court consider re-examination of a judgment which has held the field for some time, etc., etc.
Stage unfortunately has gone because reference is already made. So that issue, that argument we will not entertain more.
No,
On merit, if you want to say something.
no, that's not on the reference, Milord. That's on what the question is. Once it's referred also, in what circumstances should your lordships re-examine it and differ with it? And their lordships have not. So may I just place that judgment before your lordships, Lord?
There is a reference. Here there is already a reference. We are referring the reference.
I'm sorry, Milord.
Now there is already a reference and we are referring the reference.
Yeah, I'm saying today your lordships are being asked to re-examine and to differ with. I'm saying on the principle of.
Supreme Court rules, please see, there is as far as Chief Justice of India is concerned, the Chief Justice Supreme Court is concerned, even without, there is the precedent that you have to refer 3 to 5, 5 to 7. Chief Justice is not even bound by that rule. There is an absolute power given under the rule that Chief Justice prerogative.
I appreciate
And
that.
the order by 7 judge bench was presided over by the Chief Justice of the then Chief Justice of India.
No, I'm
So
sorry,
that issue is over now.
I'm sorry,
Ultimately,
it's my fault, Mlad. I didn't make my,
time with you.
no, I'm sorry, I didn't make my point clear, Mlad. I'm not questioning now the reference before your lordships. I'm saying even on a reference having been made, whether your lordship should differ with the judgment which has held the field for 48 years on that while answering the reference.
Authority, under what circumstances we can refuse to answer the reference. Reference is made.
Yes.
Now show us an authority which says in these circumstances, the 9-judge bench may not answer.
I'm not on not answering. I'm saying your lordships are being,
One of the contentions of Madam.
that was my contention also.
We should not, we should return the reference.
No, that was my contention also. Only on mine was primarily on the basis that today we are dealing with a repealed statute. Any interpretation your lordship's place is going to be prospective. A prospective interpretation of a repealed statute is a rather anomalous sort of situation. We do it in revenue laws. We do it in revenue laws because revenue has to be collected. But other than in revenue laws, I have never heard of.
We have done in service law. Please don't forget the judgment, the most celebrated judgment of the issuing show cause notice at the along with inquiry report.
Ramzan Khan. No, I'm talking about.
We can show you judgment in every field.
No, I'm talking about a repeal law. Your lordships are being asked to prospectively overrule a law which, an interpretation in a law which is now repealed. That's what, but I made that point. I'm not going to agitate it further.
Whatever is going to be said now will apply to the existing cases under the old law.
Mr. Sri,
That's the long and short of it.
That's the, but I made my point there. I made my point. I'm not going to repeat that. I'm on the NJAC judgment. I want to draw your lordship's attention to it. That even with the situation which you are faced with today, unless there is something which your lordships find startlingly shocking in Bangalore water supply.
Very different context, because NJC, the question was, there was a challenge and people have raised contentions that the judgment earlier was not correctly decided. NJC was constituted for the first time because the constitutional amendment was challenged. So in that challenge, they said the earlier precedent is not correctly decided. Please, 5 judges can't hear it, post it before a larger bench. That's how it arose.
No, I'm sorry, Mlad. I'm not on that. I'm saying your lordships in that judgment have examined the situation as to what are the circumstances in which judgments which have held the field for a long time should be deferred with by us. I'm only saying that there is no basis at all today for differing with it. I'm saying that 9-judge, your lordship must opine, but I'm giving your lordship reasons why you should opine in favor of upholding Bangalore water supply.
On merits, you are well within your right to argue that there is nothing new that should prompt us to revisit the judgment.
That's
a different.
In that context, I just want to place the opinion at certain parallel.
There is no need of that. Rest, we will give you 10 minutes tomorrow to you, 10-15 minutes to Gopal, and 10 minutes to Mr. Ansaria, 10 minutes to Madam, and 10 minutes to Cole.
I'll take 10 minutes.
That's all.
10
minutes each, and please give us in writing everything.